TTRLA, man, we are back with another clip. You know what I mean? Amen, say man. Go ahead and like, subscribe, and share to my channel. Like, subscribe, and share to my channel. I'm gonna give you 2 seconds. Alright, you should be good. Hey, this is the YNW Melly murder trial, day 13. Now, this is one of the last witnesses for the state. And the defense's case is basically... Well, let me tell you this. The state is bringing in an expert, well, I guess it's their expert witness who can tell them where YNW Melly was during and after the crime. So the defense is basically saying that, hey, it's scientifically, statistics proven that you can't really determine somebody's movement based on these pings. And the defense brought up an example where a husband and a wife was trying to figure out how the wife was doing 22,000 steps. And they was able to get an expert to determine that because the wife was playing the piano, the Apple Watch counted those taps as steps. So the defense's situation is basically saying, look, you can't tell where YNW Melly is because these things aren't accurate. It counts everything as a movement. It's basically what he was saying. And so the judge is, listening, but he's really trying to side with the state attorney for real. And if y'all listen to when she come up, the judge gonna say, I know you can do it. I know you lost your voice. Like, what was that about?
By an expert, it doesn't thereby transpose it and all of a sudden turn it into another issue. If that's what they need to put it in, that's what they need to put it in. If they don't, they don't. But it's incumbent upon the court to make a ruling at the time that evidence is being introduced. This is not a Dover motion. This is lack of foundation. The courts are clear. You have to establish foundation for this kind of evidence in order to put it in. You can't just, and as I said in my motion, it should not escape the court's attention that the only case that the state found to rely upon was a case out of Wisconsin, which with all due respect completely misses the point. It says, Fitbit's around for a while and everybody thinks it's reliable. So what? As I said in my motion, horoscopes have been around for a while. A lot of people think they're reliable. It doesn't make it admissible. The question is whether or not their acceptance of reliability is well-founded. And that must be established in order for it to be introduced. The state has failed to do so, and it's inadmissible judgment rejected.
You start talking about acceptable reliability. That sounds like a Dover motion to me. All right, what's the state's position?
This is not the type of information that requires any sort of expert opinion. This is not outside the scope of a regular juror's ability to understand. It shows that there was activity and that the phone was moving around at 4 a.m. It shows that the phone was moving around again at 4:40 a.m. This is corroborated by multiple sources on the phone, and pedometers, I think the first case I cited in this page to the court, pedometers have been used since 1967. This is nothing new or novel that requires any additional testimony whatsoever. Based on the background, the state would submit that the activity data is well within the purview of any juror and would be admissible.
Your Honor, just one retort. There are two components, and we're conflating issues. Expert testimony is admissible, opinion testimony, when it helps to a jury to understand an issue. In this instance, we're talking about authentication, which is this information reliable? It's not a question of whether or not they know how pedometers work. The question is whether or not a pedometer produces reliable information. Their internet is littered with instances where these pedometers have different information that differs from reality when it's tested. As I gave you an anecdote of Larry Daniels, our expert, who says his wife plays piano at church, and when she comes down from there, it says she's taken 20,000 steps because every time she taps, it reflects that there is a step. So in order for the state to advance that and the state, and Your Honor, the case that I provided concerned a static Google map. And the judgment was reversed because the proponent of the Google.
The judge was kind of mad because this defense attorney know his shit. Like he was just like on point, and he was saying all the facts he needed. But the judge was so determined to say that what the defense was saying, what needed to be not admissible. The judge was like, nah, it's admissible because of the state, provided what was needed. Basically, he was trying to basically say, but the defense was like, nah, they didn't. They didn't give us what we needed. And I shouldn't have to provide to them what we need in order to say objection.
What a horoscope is, everybody knows how it's purported to work. It doesn't mean it's accurate. It doesn't mean it's admissible. So the fact that it's been around since 19 whatever date is of no moment. The fact that jurors understand what pedometers are purported to be is of no moment. The fact that they do not have any concept or any basis upon which to predicate an understanding as to its reliability and accuracy is of importance. And that's why it's an admissible.
And Counsel, you keep going back to reliability and accuracy, and that's a Daubert motion. Authentication is what the state or whoever the proponent is that what they say it is? Boom.
The case that I cited, there was no Daubert motion, and it was a lack of authentication at the time of introduction of trial. I understand the court's conflation of the two issues, and yes, in this instance, what would be needed to authenticate it would be somebody with expertise. But it is not incumbent upon the defense to go and say, go find an expert so that I can object to it. That's not what it's about. The question is whether or not you can introduce the evidence that you bring in here into a jury. That's the issue, and it's not incumbent upon me to go through her file and determine what she needs to authenticate each piece of information and tell her to go file it, go find an expert to do it so that I can file a Daubert motion as to that expert's opinion. But I've stated my opinion, I've filed my objection, Your Honor, and we stand up. And I just note the cases that I've cited where this error was made have all been reversed.
Thank you. Have a seat. Ready to proceed?
Yes, sir.
How are you going to handle it? I know you're losing your voice. How are you going to handle it?
I'm going to start and get this. I'm going to have Ms. Smith then publish this exhibit that we were speaking about first. Was already offered to the witnesses state of approval, quintuple and certified. So I'm going to have Ms. Smith start and publishing that, and the intent is to publish the entire document.
How many pages is this?
And where's the witness? Do we know where the witness is?
21.
He's here, as my understanding.
I'm going to get him.
All right, why don't you get the witness and then bring the jury?
Hey, Melly was happy as shit in that courtroom. I don't know, man. I don't know if you facing death. Should you be smiling? I don't know. But if you innocent, would you be smiling? But if you was going to see your peoples for the last time in the world, basically, would you be, trying to have, good spirits? I mean, he looked like he looking for somebody. I don't know. But it ain't looking too good for this nigga, though. He look crazy as hell. But what I definitely can say is that this defense attorney spanking him. I mean, he really creating reasonable doubt for sure. Because I don't even know if he killed him. That was look, his breath stink. Ugh. You see how he waved his breath? That joint, she was like, damn, why not like that? My breath stink. Oh, damn, they doing him dirty as hell. He got the phone breath. Man, I'm glad he took that turtleneck off too. They had him with the soggy turtleneck. Because, look, he's stinking, underarms stinking, he's smelling real bad. I like that. See, man, that's why it's not good to commit crimes like, what the hell?
Hey, Joe, thank you. Did you see it?
I don't know. What y'all think? Y'all think he smoked them two people?
Well, I'm showing you what's been marked, previously shown to you as well.
Nah, he looked like he ready to lie. He looked like he down to say whatever she down to give him. And then they kept objecting because he was just answering the questions like, I mean, but she was just like baiting him in for the question. He looked like he ready to go ahead and wrap this case on up, and indeed he did his thing when he was on this thing, because whoo, the way it's looking, and then the jury in there, and then the judge let that be admitted. Oh, damn. It's not looking good for Brian.
At this time, the state would submit state's quintuple I as state's next numbered exhibit.
Any objection not previously raised?
Same objection.
So moved.
Oh, he just played with that man. He gonna ask him if he have an objection, and then he gonna say it's the same objection. Overruled. All players. He just spanked him.
I'm going to ask Ms. Smith to be so kind as to help publish this. If you would read the green portions of the messaging, she will read the blue and read the message, and then the date and time on the sending.
Now this part, I ain't really think it was relevant to the case, because I guess they're trying to establish motive or establish a pattern of where he was at and what he was saying prior to, or motive. But I thought that to read these text messages, this shows this was purpose. I don't think the jury is gonna get nothing from this. Like, they had other pictures to look at. Like, I don't think these text messages is gonna help anything. They already showed them pictures. I don't know why this fool was in a suitcase, but I guess because he said he was trying to hide from paparazzi, and they showed that as if that was a motive, as if he was admitting the guilt by being in a suitcase. He told them that he's in a suitcase because the paparazzi. So, the defense attorney, he doing his job, man. He definitely created reasonable doubt for sure, yeah. If YNW Melly end up beating this case, man, it'll be God and God only. I'm telling you.
At 4:11:20 p.m. They off track, never put the money in my account. I'm not paying the bill.
Like, honestly. And then she had them cheesy ass nails, girl. What was the point of this reading the text messages back and forth? Like, if I was a juror, this shit would just make me feel like the state is just doing anything. They not prepared. They don't have no real stance on something solid. They just picking a bunch of everything and just trying to make it sound sweet so they can get this death penalty. But I don't even get what the point of this whole shit right here. This is like a charade. I ain't get it.
2018 at 4:11 p.m. I did it.
Phone number ending in 6942. Message.
You see how they just try to play that right there? He was just telling the girl about the money and put the money in the account. So when he said I did it, I guess they even trying to finesse it, like to make it seem like he talking about killing somebody, because he didn't even they not. Hopefully the jurors, hopefully they understand what that text message was about, and not that he was admitting the guilt, because he was obviously talking about putting money into his account. See, the defense, boy, that state is slick. So they about to wrap it up for Monday. They coming back. They going to recess. The defense was objecting, as they should have. YNW Melly breath stink, and his underarms stinking because he kept sniffing himself. That's awful. Why they give this man some soap? But the judge seems like he is not moved though by the defense, what the defense got going on. He don't really give no flying F's, He's definitely trying to side with the prosecution, so I don't know if the defense has a good relationship with the judge. I don't know if the judge is being impartial, but yeah.